not babies, but they're teenagers, okay? So back up. She's home.
Once got basketball practice, I don't have to drive them.
Okay.
There you go.
'24 is now in session. Adequate notice of this meeting, as required by the Open Public Meetings Act of 1975, has been provided by the annual notice published in the Home News and Tribune on December 18th, 2023, and has been posted in the main lobby of the municipal complex on December 18th, 2023. Please join me in the Pledge of Allegiance to the flag.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all.
Madam Secretary, roll call, please.
Mr. Bigno? Here. Mr. Bigno? Here. Ms. Shaw?
Here.
Mr. Ayotte?
Here.
Mr. Chabra?
Here.
Mr. Cerrito?
Here.
Mr. Barone?
Here.
Mr. Sadaha?
Here.
And Chairman Kumba?
Here. Madam Secretary, minutes for consideration.
January 23, 2024, minutes for approval.
Needs to approve. Second.
Motion made by Mr. Sadata, seconded by Mr. Cerrito. Roll call, please.
Mr. Cerrito?
Yes on the motion.
Mr. Chabra?
Yes to the motion.
Mr. Barone?
Yes on the motion.
Mr. Sadaha?
Yes on the motion.
And Chairman Kumba?
Yes on the motion. Thank you, Madam Secretary.
Thank you.
Good evening, ladies and gentlemen. This is a special meeting of the Township of Edison Zoning Board of Adjustment. The board is composed of Edison Township residents appointed by the Municipal Council who volunteer their time in service to the board. The municipal land use law requires that members successfully complete a land use training course administered by the New Jersey Department of Community Affairs. This board also holds in-house training conducted by our board professionals. The zoning board abides by the provisions of the municipal land use law and to our board's bylaws. The zoning board is a quasi-judicial land use board, which differs from the township planning board. Under the municipal land use law, board members are required to be impartial and are not allowed to discuss any case prior to its consideration before the board at a hearing. All applicants will have the opportunity to present their case before the board, with the opportunity for board members and board professionals to question the applicant and their witnesses. At the conclusion of the applicant's presentation of their case, the case will be open to the public. Residents within 200 feet of the subject property will be heard, followed by residents from outside 200 feet. All residents will be sworn in. They'll provide their name and address, and they'll be given 6 minutes to comment on their application being considered without the opportunity for a rebuttal. Residents may ask questions of the applicant's professionals, and board professionals. The board requests that these questions are asked prior to any comments being made on the application. Once commentary begins, the resident's timer will begin. The applicant will be allowed for the opportunity for cross-examination of their witnesses. Under the law, the chair is allowed to stop any comment that is repetitive or is an attempt to filibuster the board. Further, the chair is allowed to stop any commentary that is irrelevant to the case or prohibited from the board's consideration. Once the public portion is closed, all public comment is ended unless new testimony is presented by the applicant. Following the closure of the public portion, the applicant will have the right of summation on their application. Following summation, the case will go to the board for a decision. This procedure has been followed by the board and is similar to the procedures followed by boards of adjustment statewide. The municipal land use law requires the board to engage in a balancing act and is not required to strictly apply township ordinances, zoning plan, or master plan. As a board of adjustment, variances are granted when appropriately necessary following all legal considerations. As has been the case with prior boards, this board will see where we are if we are in session around 10:30 p.m. I ask that the applicants, professionals, and residents show respect to each other and be civil throughout all proceedings. I ask that you withhold applause, booing, or interrupting of anyone while they are speaking. The chair will not tolerate any outbursts by applicants, professionals, or the public. Further, since most cases are being recorded by a court reporter, I ask the speakers do not speak over one another. That being said, Madam Secretary, first case on the agenda, please.
Case Z44, 2023, Arkandia Joshi, Interpretation Review, 1856 Oak Tree Road. Applicant seeks an interpretation of a 1989 ZBA-approved resolution to add an additional doctor office to be permitted at the existing office.
Good evening, Mr. Shire.
Good evening, Mr. Chairman, members of the board.
Mr. Shire, if you could bring the microphone closer to you. I can hear you, but the folks at home want to hear you.
Good evening, Mr. Chairman, members of the board. My name is Bernard Shire with the firm of Convery, and Shire. I'm representing Dr. Arkana Joshi and her husband Nilesh Joshi, who are the principals of the owner of the property at 1856 Oak Tree Road, which is and was the subject of an application made in 1989, wherein this board approved the conversion of a single-family home to a medical office on the first floor with a residential apartment on the second floor. The ordinance stipulated that there be one medical professional and one staff member in the medical office, and did not put any restrictions on the apartment above. The interpretation we're seeking is a proposal that my clients provide for a second medical professional to utilize the premises after Dr. Arkana Joshi has left the premises. Her hours are Monday through Saturday, 8:30 a.m. to 2:30 p.m. The second professional would be from 3 p.m. to 9 p.m., utilizing the existing office to treat patients of the applicant and other patients at hours when the applicant and staff are not present. I guess the real section of the ordinance we're looking at is 37-60.3, which requires for medical, dental, or chiropractic office 5 spaces for each professional person occupying or using each office. Of course, there's one office here. The basis of our argument is that the logical interpretation is if there is only one medical professional and up to one staff member present at any given time, we are in compliance, and it would be illogical to say that if there's only one medical professional present, we would in essence double the parking requirements if the ordinance were to be interpreted in that fashion. I have Mr. John DuPont with me, who's a licensed planner as well as an engineer, and I can certainly ask him if our proposed interpretation of the ordinance and the resolution would be consistent with good planning.
Without objection.
Okay, Mr. DuPont.
Mr. DuPont, raise your right hand. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
And please state your name for the record.
My name is John DuPont from JPD Engineering at 756 Jackson Road in Stewartsville, New Jersey.
Mr. DuPont has testified as an engineer and planner before this board numerous times.
I know that, Mr. Shire, but I'm going to ask him if his license are current or in good standing.
Go right ahead.
They are, thank you.
Thank you, Mr. DuPont.
Mr. DuPont, you were hired by the principals in this matter to review the issue in question with regard to adding a second medical professional to the existing office?
That is correct.
Right, and you are familiar with the Edison Township zoning ordinance requirements for parking for medical professionals?
I am.
And you're also familiar with the property in question?
That's correct.
And you've also reviewed the resolution of the zoning board from February of 1989.
I have.
Now, would a would the most logical interpretation of the parking requirements of the ordinance in accordance with the resolution be that so long as there is only one medical professional and up to one staff member present at the existing office, that would be consistent with the zoning ordinance and the resolution?
I would agree with that statement. Just from my standpoint, I did review that ordinance. The ordinance does say one professional and one staff member. It's exactly what we're proposing. There will never be two doctors. There'll be no overlap. There'll be one doctor and one professional on site working different hours. That was the only restrictions in the 89 approval resolution, and I feel we're being very consistent with that.
The board, as your attorney will note, is acting in a quasi-judicial capacity, interpreting the ordinance and resolution and how they interrelate. And I would submit that this interpretation is most logical because the reason for the parking requirements in Edison, which are among the most stringent of the municipalities in Middlesex County, is to avoid over congestion of the office and the parking situation because of the number of doctors who are present. Here, we're limiting ourselves to one physician and up to one staff member. There will never be more than one, and therefore there is no reason for the parking restrictions to be imposed in this situation. And I would ask that the board make that interpretation.
Does the board have any questions for Mr. Dupont? All right, I'll jump in the pool first. Mr. Dupont, so what you're proposing is the interpretation so that the one medical professional would operate 6 days a week from 8:30 to 2:30. Second would operate from 3 p.m. to 9 p.m. What occurs if one doctor is running late in their day?
I think there's enough time buffering, and this is those are the most extreme hours right now too. Those are the extent, but I feel there's at least an hour gap there. That is enough time to clear out and not have overlap of patients.
With all due respect, there's a half-hour gap there.
You're right. I'm sorry. You're correct.
But just to be frank, when I go to the doctor, they're never on time, and it's understood. It happens.
It does happen.
I think that if with that half-hour gap, it's intensifying the use from what the original application is.
We
was.
could make it an hour gap if that would please the board.
Mr. Chairman,
Mr. Bignell.
if I could help you. We're walking a fine line here, what's going on today as opposed to 35 years ago. And if you look at that neighborhood 35 years ago, I bet you it was a lot more residential. And back when we were all younger, the doctors lived, it was like a home practice, private practice type of deal. It doesn't say it in the resolution, so that makes it a little more difficult. But I'm sure that the hours of operation weren't until 9 o'clock at night. It might have been an emergency type of situation. I don't believe there's enough parking to keep expanding this thing, and we're broadening the scope of what was approved 35 years ago, in my opinion. So I would personally like to see a public hearing and let them prove the use variance and do all that, and then that way the public has an opportunity to see what's going on in the neighborhood, because like I said, it was 35 years ago, a lot less traffic, a lot less people, and the whole medical profession, I think, was a lot different back in those days. Plus the fact there was an RSIS. The apartment upstairs, how many bedrooms is that?
It's a two-bedroom apartment.
So that requires the 2 spaces right off the top, 1.8 spaces for the unit. Then there's a doctor and then another professional, there's 4. And then if you start bringing patients in, 1, 2 back up there, is there 6 parking spaces there, or is there 7? How many parking spaces? I don't even know.
There's 9.
There's 9. So I think that they may be able to make their case, but I think it should be done with more of a thorough examination from the board with the public having an opportunity to speak about the operation.
I agree with you.
So that's my opinion.
I completely agree with you because, and I also, with all due respect to our predecessors who put these conditions in the resolution, when this board considers applications as such, we consider things as time limits of operating hours. There's nowhere in here where it says operating hours. And my reading of the resolution, and I'm not reading it as an attorney, but I'm reading it as a zoning board member sitting here, is one means one. And I think if we start walking down the road of one could mean two, one can mean three, I think we're really, we're going on a slippery slope here. But I'll open up to the board for any other questions. Sorry, Mr. Brown.
Mr. Chairman. Mr. Shire, would your client be agreeable to start the process over and make a new application, site plan, and give us an opportunity to look at it in current time?
Well, here's my issue, and I fully understand what Mr. Bignell is saying and what you're driving at, but the board's position tonight is to interpret the zoning ordinance as it applies to this situation. It is not to decide if the board made a lousy decision 30 years ago, nor to decide if things are different today than they were then. You're talking about real planning considerations, which is Mr. Bignell's bailiwick. But the issue here is the interpretation of the ordinance. What does it say, and what does the resolution say? And what we're saying is that the ordinance should and can be interpreted to mean one doctor at a time.
Mr. Chairman,
Mr. Bignell.
if I can
Please.
add some more. The ordinance says 5 parking spaces for every medical professional, not just a doctor. So I don't believe that was even in the ordinance 35 years ago, but it is now. So theoretically, a physician assistant would require, that could be the assistant with the doctor. That right off the bat requires 10 spaces. Then it's another 1 space for every 150 square feet of gross floor area. So I don't think I think if we interpret the ordinance that Mr. Shire wants us to interpret, I think they don't have enough parking, and they should have to justify that and provide some more testimony and provide the proofs. And that's the only reason why I think they need to go through the process. And we've explained this to the applicant a few times, like he chose this route. But I think that the board should hear a thorough case. We should look at the property. We should be able to look at the lighting if we're going to go to 9 o'clock now. We were talking a residential scale back then. With a person living in the neighborhood. Now it's a renter. What happens if they have guests over, things like that. We need to examine these things and explore that stuff. And so I think if you interpret the ordinance, I think you're well within your power to say, no, this is an expansion of what was approved 35 years ago. Okay? And I think that the applicant then can certainly seek a minor site plan or a site plan approval. I don't think our ordinance allows for minor. It should, but it doesn't. And then seek the use variance to continue and to expand. And then we can kind of like lock in the hours of operation and how we're going to enforce whether there's 2 doctors there or not. And that's what makes it difficult here. It's very difficult to kind of do that stuff, even from a zoning point of view. How would Mr. Ayotte know or his staff know how many doctors are at any one time? Taking people's word for it. The road to hell is paved with good intentions. And we've seen it all over town where everybody's supposed to do what they're supposed to do, but they don't. And not to say that this applicant wouldn't, but we have to be able to enforce those things. And so I would feel a whole lot more comfortable if we went through the process. So that would be my recommendation to the board and during your interpretation.
Yep.
All right?
Mr. Chairman, if I may respond.
Sure.
Once again, those are extremely valid planning concepts, but that is not what the board's job is tonight. And I would defer to your board attorney perhaps to expand on what I'm saying, but I anticipated an argument about how do you enforce it, and very frankly, that would draw into question every single medical office that's been approved for a number of doctors in this town forever. Because if it's approved for 2, What's to stop 3? If it's approved for 3, what's to stop 4? How do you enforce it? You enforce it when there's a problem and they see that there's too much traffic and they find out. Or maybe the sign has 3 names on it. But that is not related to the interpretation of the ordinance. The interpretation of the ordinance is simply whether we comply by having 1 doctor at a time. We're not asking for a physician's assistant. We're not asking for anything else except 1 doctor at a time, plus up to 1 staff, meaning a nurse or a secretary. And that is I realize that this doesn't come before the board very often, but you're not here to determine if this is a good thing from a planning concept.
Now, Mr. Chairman, with all due respect to Mr. Shire, you're interpreting 2 things. You're interpreting the ordinance, so that he's correct, but you're also interpreting a prior approval, and he's not living within that prior approval, in my professional opinion. And it's my position to protect the community. Okay, and I don't personally. If it's a nurse, now it's a professional. So now we're required to have 10 parking spaces and then add up the square footage. Okay, the ordinance didn't anticipate medical professionals. They didn't have them back then. The physician assistant or the nurse that could, the registered nurse that had all the extra powers that we give medical professionals today because of the shortage of doctors. My point to you is that you're supposed to interpret the ordinance, but also what was approved. He's asking you to change conditions of an approved without going through the public process or the public hearing portion of it. I mean, we can stand and argue this all day long, but that's my position, and I think, I think the ordinance, it's 35 years ago. Again, the community changed, the neighborhoods have changed, the traffic has changed. I'm sure I bet you a lot that the doctor didn't have 9 o'clock office hours back 35 years ago, because that's not the way the profession was 35 years ago. So that's where I'm at. So it's a 2 thing. You're looking at the ordinance, and if I apply the ordinance, then I think he has even a deeper problem because of what the ordinance says for parking. The 2 uses on the property. So now we're interpreting the ordinance and the conditions of approval.
Thank you, Mr. Guido.
So,
Ms. Shaw.
yeah, I think I need to chime in at this point. So I understand what Mr. Shire is saying. I also understand what Mr. Bignell is saying. Put simply, you do have to take a look at the resolution because the resolution approved an application for which we don't have sufficient information within even the resolution to indicate what was testified to other than the conditions that Mr. Shire correctly placed on the record. Notwithstanding, it's very clear a literal reading of the resolution indicates 1 medical profession. Now you have to read that in conjunction with what Mr. Shire is requesting, which is an interpretation of the ordinance, and stating that do they comply if they have 1 medical profession at one time or another. Not knowing what the testimony was back then that led the board to grant this approval, it's hard to opine or provide an opinion that 1 medical profession meant somebody in a neighborhood that was perhaps changing, because it does indicate within the resolution that within a half mile of the site there are other professional buildings, but it also says it's a mixed use, and not fully understanding the gravity or the scope of what was testified to. The board has to look at that resolution and interpret the ordinance to see if it is accurate to say that, because this was a variance approval. And I'm guessing, Mr. Shire, what I heard a few minutes ago from the board itself is that their thought process is that they have a very limited scope in reviewing it, and literally reviewing it, it indicates 1 medical profession, and now we're looking for 2 medical professions, putting aside the fact that that's the condition, and then I understand that you have to read the ordinance. So I'm not sure there's enough here for that interpretation to be that, yes, this fully complies, or no, it doesn't comply. I know that was a completely useless and unhelpful recitation of what's there, but he is entitled to an interpretation of the ordinance, but you can't disregard the resolution because that's how this use came about. And the resolution seems to the literal reading seems to be one medical profession. So, I don't give you much guidance, I apologize.
Chair?
Mr. Ayotte?
Fill me in. If you have one doctor, let's just say he came from 7 to 3, another doctor came from 4 to 12 with his own assistant, and then another doctor came from 1 to 7 in the morning, so with their assistant. So how many people, how many employees would be in that building? There would be 3 doctors working in a 24-hour period, and there would be 3 assistants working in the 24-hour period. So that would be a total of 6. Okay, so, I mean, they're not asking to exceed the hours here, but they're asking to exceed the number of employees.
Well, it's the question isn't within a 24-hour period. The logical import of the ordinance is how many are there at a given time.
Doesn't say that in the
It doesn't, but
resolution.
it does not say
I know what
how
you're saying,
many
Skip.
altogether in 24 hours. I mean, if you had 3 doctors there in 24 hours and interpreted the ordinance the way some of the board members may want to interpret it, that would mean we need 15 spaces plus 1 space for each 150 square feet. That is not a logical interpretation of the ordinance unless we're asking for 3 to be there at any given time.
All due respect, Skip, I understand what you're saying, but I'm thinking of the resolution, not the ordinance, and the resolution clearly dictates 1 employee, 1 doctor, 1 assistant, 1 medical assistant. It doesn't say 2 more maybe coming in, 3 more part-time. You know, it's 1, and that's in black and white in the resolution.
The issue is, what does the ordinance mean? I mean, are we going to require, if there are 2 doctors, let's say there were 4 hours between the hours the doctors practice there, does that mean we still need 10 spaces for 2 doctors?
You always have to have the correct
Even though there's
amount of
only 1 there
spaces.
at a given moment?
Gentlemen, if you could only speak one at a time, please. The court reporter is trying to take a transcript of the proceedings. Thank you.
Thank you, Chair. I'm good.
You may continue, Mr. Ayotte.
That's all. I appreciate it.
Mr. Dupont, Mr. Shar, do you have anything else to add?
No, I made my presentation, and I'll be satisfied if the board makes their interpretation of the ordinance as requested.
Ms. Shaw, as a matter of procedure, do we go out to the public for something like this, or?
There's no public notice required, it's an interpretation, it's the
Okay.
board's quasi-judicial
Okay.
obligation.
Okay,
Yeah.
all right, thank you. I just wanted to be sure. Does the board have anything to add, or does the board have any discussions or motions? Ms. Brown?
Chair. Mr. Shire, is there a site plan from previous?
Yes, there was a
Was
site
that
plan
submitted?
prepared by Angelo Valatudo back in 1989?
89.
1989.
But was it submitted under
believe
your
it was.
application?
I believe we were able to get it and submit it. If the board does not have it, let me just see it.
Our position, I mean, the secretary's position is we don't have it.
Mr. Chairman,
Mr. Brunel?
that's the reason why I'd like you to have a public hearing. I mean,
So I
we're going in a
think,
circle now.
I think that Mr. Brown's asking, because on the application for interpretation, the last line says copies of the existing site plan are provided for informational purposes. I think that's what he's referencing.
Yes.
I thought I did. If the board would like to withhold their decision until they see it, I believe I do have it from Mr. Valatudo. I do have it. If the board would like me to submit adequate copies of it before they make their determination, I'd be happy to do that.
Who decides that?
Ms. Brown?
No, I'm asking if that's acceptable.
If that's something that you'd like to see, you can request it. I mean, if it's something the rest of the board would like to see, they can request it. I don't, personally, I don't see, it's interpretation, so I don't see where the site plan would make the biggest difference, but if it
Mr.
makes.
Chair, what I was really alluding to is that I think the site plan then, or a site plan now, and more importantly now, would be what's required. And to Mr. Bignell's testimony, I can say that, and I don't like giving commentary, but I hope this doesn't come across that way, but maybe your application, if this resolution did not exist, your application today in what you want to do, even with one doctor and one staff member, may be challenging based on changing parking regulations and ratios. Just saying.
Just to be clear, he's asking for an interpretation of what the proposal would be if it fits within the ordinance and if it complies with the ordinance. And I think I think you've heard Mr. Ayotte raise some concerns, Mr. Bignell raise some concerns, and I'm not sure the site plan in and of itself would be sufficient to respond to that or even make a difference in the interpretation is what they're seeking at this stage. They haven't come in for an application yet, which is what Mr. Bignell has suggested should occur. But again, it's up to the board to make this determination on
I
interpretation.
understand. I defer to the people. Mr. Shire, I think Madam Attorney reiterated that if you had a new application now, then we can look at it fresh.
No, they're not.
I can't.
Okay,
I'll defer to the others as to position of the board.
Mr. Chhabra?
Yes, Mr. Chairman. I feel that given the changes in regulations, changes in the neighborhood, the traffic patterns itself, I definitely feel like the public hearing would be essential in making this decision. We know that the neighborhood itself has changed a lot over the course of the last 30 years, and definitely feel like we should keep in consideration all the attributes.
Thank you.
If that's your position, is it that you're making a motion that the interpretation does not permit what they're proposing? So that is what I need to know. Because there has to be a motion made that the interpretation with respect to the ordinance is that the proposal is inconsistent. Is that the motion?
Yes, I'd like to make a motion that the proposal is inconsistent with the resolution.
I would second that motion.
All right, motion made by Mr. Chhabra, seconded by Mr. Barone.
Just to be clear, it's inconsistent with the resolution and the ordinance? Is that, or is it, and I don't want to put words in your mouth, what, we're interpreting the ordinance, so I want to be clear as to their proposal. Is it in, what you're saying, it's inconsistent with both one or the other?
Now, correct me if I'm wrong, this was created by use variance.
It was created by
So
use
we're
variance.
expanding, in my mind, we're expanding a non-conforming use, so it's, whether it complies with the ordinance or not, we're expanding a non-conforming use by adding people to this operation. So that's why I wanted to go back as a use variance to the board. Was my position. So I want everybody to understand that. So we're not just interpreting the ordinance, we're interpreting a decision that was made. So now we're expanding, if you allow more doctors onto the property, theoretically, you're expanding a non-conforming use.
Correct, but the request is for an interpretation of the ordinance, and his motion was that it is inconsistent with the resolution. So I want to make sure that it's the resolution and what exactly they're saying.
Okay, but if you don't, if you say, all right, he complies with the ordinance, what he's still asking us to do is expand the non-conforming use, so it still doesn't get him anywhere.
But the board has to
Okay, well, I
make
want
the
you to understand the
appropriate
nuance
motion.
of it, yeah, okay.
Yeah.
All right, motion made by Mr. Chhabra, seconded by Mr. Barone. Roll call, please.
But I still need to know, what exactly
Okay.
are you saying? Sorry, I apologize,
Mr.
but I got to
Mr.
write
Chhabra.
this.
Inconsistent with the current use.
So it's, okay, I think I understand it. Mr. Shire, do you understand it?
I'm trying.
Okay, so that the proposal, so I'm going to try to summarize it, and the board can tell me if this is correct language. The motion is that the proposed use is inconsistent with the current use in having interpreted the ordinance. Is that correct?
I would say in interpreting the ordinance and also in interpreting the resolution of KZ 122-88.
Clear?
Madam Secretary, roll call, please.
Mr. Chabra?
Yes to the motion.
Mr. Cerrito?
Yes on the motion.
Mr. Barone?
Yes.
Mr. Sadaha?
Yes on the motion.
And Chairman Kumba?
Yes on the motion. Thank you.
Okay, so denied.
Will there be a written resolution?
Can you bring the microphone closer, please?
Will there be a written resolution adopted?
I would presume I would have to
Okay.
prepare one.
Thank you very much.
Thank you.
Does the board need a transcript?
Michelle?
Not on this, it's going to be a simple resolution because this was an interpretive request.
Thank you.
But obviously, if you intend to go further, Mr. Shire, you know we will need it.
Good to see you all.
Thank you. Okay, we're going to take a 2-minute break. We'll be back at 7:38. We'll return to session. Madam Secretary, next case on the agenda, please.
Case number Z39, 2023, Divya Properties at 222 Nicholson Ave. Applicant is seeking a bulk variance to construct a second-story deck to a single-family dwelling under construction. Rear yard setback required is 30% of lot depth. Proposed is 17.73%. Affected property is located in the RBB zone, designated as block number 913, lot number 12 on the Edison Township tax map. All noticing paperwork is in order.
Good evening, Mr. Wiley.
Good evening. I represent the applicant, Divya Properties. I have the owner of Divya Properties who will be my witness. As one could tell, this is a relatively small application. Originally, there was approval for a 220-foot paver patio when the original plans were submitted back in 2021. My client has decided that he would prefer to build a deck of 293 square feet. However, that would require a new rear yard variance. I believe 37.5 would be the distance that would be required under the ordinance, and we have 19.5. At this point, I'd like to swear in my witness.
Sir, would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
Yes, I will.
If you can pull the microphone closer and state your full name for the record.
Divyakant Patel. Will I spell it for you?
Yeah.
Divyakant.
And what is your position with Divya Properties?
I'm the president of the corporation.
And you're in charge of the construction of this single-family house? Or you
I'm
hired
just a-
people to build it for you, but you're the one that has determined that he would like to have a deck. Is that correct?
Yes, that's correct.
Okay. And this deck would be in the rear of the property, is that correct?
Yes.
And the deck would run out from an area at the level of what might be called the first floor, but it is actually raised as a result of there being a basement. Is that correct?
Yes.
And its dimensions are 293 square feet. Is that correct?
Yes.
And what is the purpose of the deck?
It's just using for the sit down on evening hours or in the weekends. It's
And
Family
there
use.
would be a set of stairs running from the deck to the ground. Is that correct?
yes.
And under the plans that had been previously approved by the board, there is a requirement of considerable screening in the rear, in fact, all around the rear yard. Is that correct?
Yes.
I have really no further questions to this witness.
Does the board have any questions for the applicant?
Yes, Mr. Chairman, I do have a question for the applicant.
You may proceed.
So from your resolution of 2019, it looks like you have 3 variances already granted on the property. Is that correct?
He was not the applicant, but that is correct. I was the attorney, so that is correct.
Okay. And what, if I may ask, what is the hardship for this deck that you're seeking?
Prior, he had a patio, a paver patio that was running really at the ground level. And he feels it would be more functional if he had a deck instead that one could enter on the first floor and exit onto the deck, and from there, he could then proceed to the ground if the future buyer wanted to.
And that previous paver patio, how many square feet was that?
220 square feet.
Okay. All right, thank you.
Thank you, Mr. Chauver. Does the board have any other questions for the applicant? Okay. Mr. Brown, all right. Okay. Mr. Wiley, do you have anything to add?
I have nothing to add.
Okay. All right. So we will now go out to the public. If anyone within 200 feet of the subject property wanting to be heard, if you're within 200 feet of the subject property, you received a notice via certified mail. Please, come on up. Come on up, sir. Yes, please, to the podium. And then the attorney will swear you in.
Sir, raise your right hand. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
And please state your full name for the record, providing your address as well.
Full name is Avtar Singh.
I'm sorry.
Avtar Singh. AVTARSINGH. A resident of 223 Fletcher Street in Edison, New Jersey.
Thank you, sir. You may proceed. You have 6 minutes.
Okay, I've been a humble resident of Edison for the last about 25 years, and I live in the property directly behind this said property, which is on note here. My only concern, I've got nothing personal against anybody, but my only concern is it'll be an intrusion into our privacy because of the height of the deck, which is overlooking our area directly. So that impeaches our privacy altogether, and it's not welcomed.
Okay.
In addition, I also have a signed letter from another resident.
I'm sorry, sir, you can't present a signed letter nor read it. That person has to actually be present.
Oh, all right.
If I may ask the applicant, the witness a question?
Sir, would you mind,
yeah.
Mr. Wiley, ask you a question?
Yeah, sure.
Are you aware that the height of the deck would be 7 feet?
I'm sorry?
Are you aware that the height of the deck in the rear would be 7 feet?
Yes, 7 feet, which is much above the height of a person standing on the back of our house. And it overlooks the backyard.
And you're aware that there is screening required by the previous approval that could go as high as 7 or 8 feet?
Screening on the deck?
On the rear lot line. You're lot 11, I believe?
I don't understand the question.
Okay. You're directly in the rear, which I assume is a lot 11?
I'm not sure of the
Or you're
number.
not sure what it is, but you have a shed in the rear of your property?
Yes.
Okay. And you are aware that along the rear property line, we are required to provide plantings, and we can increase the height of the plantings if the board wants, so that this would be obscured to you.
I'll be required to do the planting?
No, we are required to do the planting already. We could increase the height of the planting if it's a concern of yours.
But that'll take several years.
No, what they're saying, so, sir, just for interpretation, I don't want to, but, so, as part of their prior approval to build the home that they're building, they're required, and Mr. Wiley can correct me if I'm wrong, but they are required to put 7 feet, for a tree line, which would be 7 feet high, correct, Mr. Wiley?
Correct.
And what you're offering is to go higher, so that what they would plant would not be a 7-foot tree, but maybe they would plant an 8-foot tree or a 9-foot tree, so as to help for the natural buffering.
But if the deck itself is 7 feet high, even 8 foot or 9 feet high buffering is not enough to grant any privacy to the neighbor. Unless it is like 7 feet higher than the foot level of the deck, then I can understand. Because the normal person height is, let's say, 6 feet, and if there is a buffering of 7 feet, that is sufficient. But there should be some privacy in the world we live in.
Okay, I was just interpreting what Mr. Wiley was
Yeah,
offering.
I'm also telling you what I feel about the buffering.
Mr. Chair,
Mr. Ayotte.
if I may, the plans show the deck at 4 feet, 10 and a half inches from the grade to the bottom of the first joist. You have a 2 by 10 joist. Let's call it a 2 by 12. You have 5 foot to the deck. Where you get,
But, yeah, my client said 7, but he's undoubtedly incorrect. It's 4, it's
you
level
got
with that
4
floor.
4 foot, 10 and a half inches.
Yeah,
It's not 7 feet. You're going to plant, you're proposing to plant 7 foot, 8 foot trees, and the
Right.
decks have 4 foot, so you got,
yep.
so the deck, does everyone see that's on the second, A2? To the right and center of where it says transverse section, the deck shows 4 feet, 10 and a half inches.
Thank you, Mr. Ayotte. Sir, do you have anything else to add?
Thank you.
Do you have anything else to say?
No.
Okay. All right. Thank you very much, sir. We appreciate it. Is there anyone else within 200 feet of the subject property wanting to be heard? Anyone outside of 200 feet of the subject property wanting to be heard? All right. So with that being said, Mr. Wiley, do you have anything to add?
I have nothing to add.
Okay. Can I get a motion to close the public portion?
Motion to close.
Second.
Motion made by Mr. Sadata, second by Mr. Cerrito. All in favor signify by saying aye. Opposed, nay. The ayes have it. Public portion is now closed. Mr. Wiley, do you have any summation prior to going to the board?
As I indicated, we're willing to plant 7-foot trees here to obscure the neighbor to our rear.
Okay. All right. Thank you, Mr. Wiley. That's it?
That's it.
Thank you. All right, so we will go to the board. Any discussion or motions?
Motion to approve, provided the plants are, enough height plants are planted in the back of the property.
Second.
Motion made by Mr. Sadata, seconded by Mr. Cerrito. Roll call, please.
Mr. Chabra?
Yes to the motion.
Mr. Cerrito?
Yes on the motion.
Mr. Brown?
Wait,
No.
Sorry,
It's
the
on the
public
motion.
portion was closed. We looked, when we asked for the public portion, but we cannot, the public portion, Ms. Shaw?
Public portion was closed. Sorry.
Okay. Roll call, please.
Mr. Brown?
yes on the motion?
Mr. Sadaha?
Yes on the motion.
And Chairman Kamba?
Yes on the motion. Congratulations. Okay, we're going to take a 5-minute recess to allow the court reporter to set up for the next case.
Yep. Even if it's a small
All right, we will return to session. Madam Secretary, next case on the agenda, please.
Case number Z37, 2023, Equistar Chemicals LP, 340 Meadow Road. Applicant is seeking bulk and D-use variances to replace an existing accessory structure, scrubber structure on the site. Standards have not been met in accordance with the master plan. Chemical plants are not a permitted use in this zone. Building height required is 100 feet, proposed is 120 feet. Affected property is located in the L1 zone, designated as block number 366.02 and 302 / lot number 16 on the Edison Township tax map. All noticing paperwork is in order.
Thank you. Good evening.
Good evening, Chairman. For the record, Joe Papero from Porzio, Bromberg, and Newman on behalf of Equistar Chemicals, LP. As mentioned in the summary, this is an application for the existing facility at 340 Meadow Road. We are here for site plan and variance approvals for the installation of new equipment and the replacement of existing equipment at the facility. This site is located in the LI Light Industrial Zone. The light industrial zone permits the existing use. I'll defer to council, I think.
Hold on 1 minute.
Chair,
Mr. Srita.
I would like to recuse myself from this case.
Yes. Thank you, Mr. Srita.
Thank you very much. I apologize.
No problem.
As I was saying, this site is located in the LI Light Industrial Zone. Industrial uses are permitted. We'll have our experts discuss those aspects of the facility. However, preliminarily, I would note that there is no change to the existing use at the facility. This is a replacement and an upgrade of existing equipment. No expansion of the use, no change in the use. The variance relief that we are seeking, and the reason why this board has jurisdiction, is the height of the equipment. The ordinance limits height to 100 feet. The proposed equipment is at 120 feet. Because the proposed height exceeds the allowance by more than 10 feet or 10%, that triggers a D6 use variance according to the municipal land use law. Only this board has jurisdiction to approve such a variance, and that is the request before you this evening. For witnesses this evening, I will call a representative of Equistar, and then I will conclude my presentation with the site engineer and planner to justify the variance relief that we're seeking. So, Chairman, if there are no preliminary questions, I'd like to begin with Mr. Feemster on behalf of Equistar.
Does the board have any preliminary questions? Seeing none, you may proceed.
Sir, would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth and nothing but the truth, so help you God?
Yes, ma'am.
And please state your full name for the record.
My name is Daniel Feemster. I am the site manager of the Lyondell-Basell, also known as Equistar facility in Edison, New Jersey.
Mr. Feemster, for the benefit of the board and the public, can you just provide your position with the company and what your day-to-day responsibilities are?
Again, I'm the site manager of the site, so highest ranking officer at this location. I've been with Lyondell-Basell for 6 years. I've been at this site for a year. I'm a mechanical engineer by degree and been in the industry for about 16 years. Again, all the activities at the site fall under my purview from day-to-day activities and things like this construction project.
Can you provide, for those that may not be familiar, what's an overview or provide an overview of Equistar's day-to-day operations? What are the services it provides?
So Equistar is a global manufacturer of chemicals. This site here in Edison provides catalyst for polyolefin processes, the manufacturing of plastic.
I mentioned in my overview that we are proposing to replace existing equipment with new equipment, and the height differential is triggering the need for variance relief from this board. Can you describe the purpose for this new equipment and what function it will serve?
So this new equipment is replacing some aged equipment. The equipment itself is 30 years old. And what we're looking to do is to upgrade and improve to the new technology that's available nowadays. The piece of equipment. The piece of equipment is a process scrubber. It helps us with our environmental emissions. And so we're looking to continually improve our processes. This is part of that. And so we're investing in the betterment of this piece of equipment. The reason for the variance, the existing one is 80 feet. We're looking to get the variance to 120 feet. The reason being is we have a column on site that sits at 114 feet. Industry standards and our company standards want that height of a discharge of a emission to be above any occupiable platform. So we're looking to comply with both our internal company as well as general industry standards.
The proposed equipment that will not be manned, correct?
Correct. The equipment that we are installing does not change our headcount or our employees on site. And there's no reason to access the top of this equipment or anything of that nature.
There's no building structure or real floor area associated with this. It's the scrubber equipment and column that you described, correct?
Correct.
And I know the engineer will come up next with more technical testimony, but I just wanted to confirm that this new equipment will not result in an expansion of your operations. You're not offering a new product line or anything of that nature. Is that correct?
Correct. This equipment has no production value for us. It's purely environmental. And again, I want to emphasize that it is a betterment to an aged piece of equipment that we're looking to replace.
Again, we have an engineer and a planner who will come up next to identify on the plans where this equipment will be located. But generally speaking, the proposed equipment to be replaced and the new installation are generally in the same vicinity on the site. Is that accurate?
Roughly in the same area.
Chairman, I have no further direct for this witness at this time.
Thank you. Does the board have any questions for Mr. Feemster? Mr. Brown?
Mr. Chair, I'm sorry, I didn't get your last name, Daniel?
Feemster.
Feemster?
Feemster. Teamster with an F.
Sir, you're a plastic manufacturer. I heard that in your opening.
So we're a manufacturer of catalyst that's used in the production of plastic. We do not produce plastic on site.
I'm just asking, what is it then? What's the end product? I don't understand it.
It's a catalyst. We produce, it's a solid catalyst that is used then by other manufacturers and ourselves to subsequently react with ethylene or polyethylene or propylene to produce plastic.
But no plastic is produced at site. You produce the chemical, for lack of a better word.
Correct. We produce a solid chemical.
Also, in your testimony, you mentioned environmental. Can you expand on that a little bit, like in terms of how that connects to your application?
So this piece of equipment is a scrubber. What it does is it allows us to change a chemical before we release it to the environment. And so the old piece of equipment would say scrub roughly 80 to 90% of an emission, where the newer equipment with the new technology would allow us to get up to 98, 99% efficiencies in our scrubbing capacities.
So the discharge is much cleaner than
much better.
Existing, and all right. And no other environmental, I asked a question if there were any other environmental parts to this application, since environmental is involved. I mean, I'm just asking.
For us, no. Again, we're replacing an existing piece of equipment.
Thank you, Daniel.
Thank you, Mr.
I'm
Brown.
good.
Mr. Chairman,
Mr. McDowell?
I have one question. Is the plant in complete operation right now?
Yes, it is.
Thank you.
Mr. Stada?
How are you transporting that chemical? How are you transporting that chemical to the other facility?
So our chemicals and products are transported via truck.
Thank you.
Does the board have any other questions for Mr. Feemster? Actually, I have one question. So you, just seeing the history of this, so you came in 2018 looking for 106 feet, 2019, 114 feet, now you're going 120 feet. If so approved, should I expect you in another year or two coming back before us for?
No, sir. Again, the expansion that was done before to get to that 114 foot kind of set that limit for us. And again, this is that top limit above that discharges need to be to meet our industry and company regulations.
So the technology is there. The technology is
Yeah,
where.
we are not seeking an expansion at this time at this facility.
Okay. All right. Thank you very much. Any other questions? Okay. All right. Thank you.
Thank you very much. Thank you, Mr. Feemster. Our next and final witness is our project engineer and planner, Robert Walsh.
Sir, would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
Yes, I do.
And please state your full name for the record.
Robert E. Walsh, Chief Civil and Environmental Engineer of EI Associates located at 8 Ridgedale Avenue, Cedar Knolls, New Jersey, 07927.
Mr. Walsh, I'm sorry.
And Mr. Walsh, if you could just present your qualifications.
Yeah, I'm a licensed engineer in New Jersey, New York, and Pennsylvania, and a licensed professional planner. I've testified in over 100 municipalities.
You can bring the microphone closer to you.
Sorry. As well as I presented the last presentation. If you have questions about the prior application, I provided testimony for that, both the planning board, which was 2018, and then later in 2018, and ultimately the resolution for the 114-foot height was approved in 2019.
And your licenses are current and in good standing?
Yes.
Okay, we'll accept you.
Thank you, Chairman.
Thank you.
Mr. Walsh, I know you have a number of exhibits this evening. Why don't we, if we could, start with what's being displayed on the television screens. We do have handouts for the board members. We can mark this A1.
Okay, there's Counselor, there's nothing on the screens.
Oh, okay. I see it on these ones. I
These two
apologize.
screens here.
For the
That's
public.
great, the board's here, because we have one screen here.
I followed the instructions.
No, earlier it was showing earlier. It was? It was. Before we started.
Probably off.
Oh, it is showing on
Probably off. The red lights.
Yeah.
These yours, right? Yeah, look. You need to put it on.
Thank you.
Now it's off.
Oh, there you go. You got it, Raj. Thanks.
Oh, we're
Check the Rangers score while you're at it there.
That's the one. So you got all of them in there? Is that what you're saying?
The board? Okay.
No looking.
Okay. So the exhibits that are being passed around now consist of what I'm showing first, an aerial image which is a photo location plan and 3 photographs, so it's 4 pages. And then the 6 drawing sheets will be presented that are the same drawings that were submitted to the board, Revision B, July 27th, 2023, with a little bit of color on it so it makes it easier to read on the screen. So you can number them. If you want to do each individual sheet, I got no problem.
We'll do A1 for the first packet and then A2, if we could, for the second packet, the rendered site plan. And I'm going to hand those now. Mr. Walsh, if you could describe for the board what's depicted in Exhibit A1, the aerial exhibit. You have some of the proposed improvements highlighted. If you could walk the board and the public through those images which have been marked as Exhibit A1.
So the first page of the A1 exhibit is an aerial image identified as drawing PL photo location 01, and it's dated 1/29/2024. Basically what it shows, the red dot is the column that was approved in 18-19, to be 114 feet tall. That was built and it stays in place. It's not being altered. The blue dot represents the existing and proposed location of the vent stack associated with the scrubber. The two yellow symbols down in the lower portion are the photographs 1 and 2, which will follow right after this. They're taken from the town facility, the boat launch area. We used that in 2018. We had a photo rendering. We took down the Titan process that was approved in 18-19, was taken down and replaced with new facilities, higher technology, more efficiency, and we used that vantage point to present the application at that time. So I'm going to jump to the first photograph, and there's actually 3 photographs in there, and the third photograph is merely photograph 2 with a little zoomed in view. So this is from the footbridge located at the boat launch area. What I've identified on the right is this structure that was installed in 2018-19. It's 114 feet. And there's a very skinny tower behind a tree that you can barely make out. And just for reference, when you see the plans, the structure, it's kind of an open structure. It's got a little tan section furthest to the right where the 114-foot column is located. That is identified on the site plan as Building 2. The tan building in the middle is Building 6, and I believe it's Building 10 is the tan building furthest to the left. So we're next to Building 6 with the proposed vent stack, which will be changed from 80 feet to 120. Then photograph number 2 is basically in the like photograph number 1, where that truck is in the foreground. That's where we're taking the photograph now. So you can get a little better idea. It's a very skinny column, the one on the left that's getting replaced. It'll be replaced by a vent stack that's 20 inches in diameter, which is shown on this site plan. So you can see that it's hard to really see that, and the new vent stack will be approximately the height of the 114, 6 feet taller. And bear in mind that the height of the column that was constructed, with that 114 goes to a height that's the top of the physical column, which is a 4-foot diameter distillation column, and it has a platform with a 42-inch high railing around it. So that it's actually slightly higher. It's essentially, from this vantage point, it's going to be the same height. And then again, so you can see it a little better with photograph number 3. You could see there's I'm going to zoom in here. You can see there's a platform on the highest piece of equipment, which is what we got the variance for. And then you could see basically that standalone column way to the left. And I hope you can see that on the screen because I think it shows it a little better when I zoom in. So that's the one on the left is what we're replacing. And that is Exhibit 1A, correct?
Correct. A1.
A1. Now I'm going to go to the site plan drawings of 6 sheets consisting of the title sheet T1, C01, and then C02, and then A1, A2, and A3 are the drawing numbers. And again, they're the same ones that were submitted with the application package. However, we've indicated some features in red. So the first sheet of this, come on, baby. Now it doesn't want to zoom.
They're frozen.
Yeah, it's gonna get no blue wheel. The overall property, which is shown on T01 of this packet, is outlined in purple. That's about 90 acres. The portion of the property where all the development has occurred and where most of the 18% impervious coverage is in the eastern part of the site, and it represents about 18% impervious coverage. So that's where the project location is. I should note that the distance from that project, or that project work area, the red dot there, over to the Meadow Road, which it runs kind of north-south to the right of that closest property corner, which is the corner where we meet the town property, that's 460 feet to that point, just for reference. And this is an enlarged plan. Again, this is a drawing number C01, the site plan. This is rotated 90 degrees. North is no longer going up the page like it shows on T01, but it's to the right. So Meadow Road is on the bottom of the sheet, and Midvale Road is to the right. We show a section line in there because on the last architectural elevation view, you'll see we'll show building 10, 6, and 2, but we just turned that section line because we took one of the old exhibits for the original project and we just put that in the elevation. So it's really changes to a east view but you'll see when we get to that exhibit. And then this is an enlarged plan, same orientation as the C01 is C02 to show where it is next to building number 6. And I'm gonna hop quickly to A1, which is a plan view with architectural dimensions to show you that the work area is basically a 24 by 15-foot platform. And you see where to the left-hand side where I've zoomed in, there's 4 base plates and foundations to the left, and it says centerline of vertical stack. That's where the column will be built, or the vent stack. There'll be a frame, and that'll go up. And the equipment is located to the right of those columns. And what it consists of is the scrubber unit, which is a large diameter circle, which has a blower and then a pump to pump the water and does the actual scrubbing of the material that's captured. Then I'm going to drawing number A2, which has 2 enlarged elevations. These are looking in an easterly direction, or west elevation. The one on the left shows proportionally the elevation of the stack relative to the equipment, whereas the one on the right, there's a break line in the stack to give a larger view of the equipment. And again, that equipment shows that it's at ground level. The scrubber unit itself is about 28 feet. Yes, 28 feet. And then again, the stack is a 20-inch diameter vent that goes up.
Mr. Walsh, not to interrupt you, but I have
Sure.
a quick just clarification. When you compare, looking at A2, and you compare the elevation of the stack and the equipment to what was approved and constructed in 2019, is it fair to say this is less substantial of a piece of equipment based on the amount of platform and associated material?
Oh, absolutely. Much smaller. And again, this is a piece of equipment that's been there. It's not getting moved around. It's purely a upgrade in technology and level of treatment. And then lastly, I have that exhibit that's referenced on the site plan where you could see the relative height to the prior project, where to the far right you have what was the eastern elevation of the building and structures that were constructed in 2019.
And this goes to the point that we just discussed. When you compare the image to the right, that's the installation that was approved by
Correct.
the board and installed versus what's highlighted, outlined in red is the proposal. The mass of it is significantly lower, correct?
Correct.
Mr. Walsh, you've analyzed this application due to the need for a planning variance, a D6 height variance for the stack, which exceeds the ordinance allowance by more than 10 feet or 10%. Can you provide your planning opinion, your professional planning opinion regarding the requested variance, identifying the positive and negative statutory criteria?
Sure. First of all, as testified by Mr. Feimster, this is going to be an increase in technology, and basically, from the positive criteria, it's meets the benefit of the health and safety of the general public, as well as the workers who are on site. As Mr. Feimster pointed out, the stack elevation or vent elevation is being set by an industry standard. For people who may be working on that platform, they're discharging at 6 feet higher than the platform height that was recently constructed. As far as the impact to the adjoining neighborhood, this is all industrial zone here, and as you can see from the photographs, it's quite a distance to that equipment, and visually, there's going to be, I don't think it's going to be noticeable, in my opinion, and there are no residential views or anything from that area. And if you go to the other side of the site and you go to, which is also industrial zone, where it goes upgrade and everything, it's less of a, there's more trees blocking it because they're higher in elevation, and those trees are basically blocking the view of the existing facility. As far as being consistent or not inconsistent with the zone plan, I think in the L1 zone or LI zone allows telecommunication towers, and unlike the restricted industrial zone where it's specifically limited to 150 feet, in this zone it's based on the fall zone, which states that any different zone property line to the base of the tower is the permitted height, and as I mentioned before, that's 460 feet to the corner of the, so in theory, you could have a 460-foot tower here and it would meet the requirements of that conditional use identified in the LI zone. So, and then again, finally, it's the master plan identifies this as a LI zone. It's consistent. We're not changing anything. We're not expanding the use. It's basically a change of equipment and a benefit to the health and public safety, as I said, the people working on site as well as the adjoining properties.
Mr. Walsh, to that point, one of the purposes of the municipal land use law purposes of zoning is the public health, safety, and welfare, correct?
Correct.
Mr. Feimster's testimony is that this technology will reduce the emissions and clean the emissions to a higher standard. I believe his testimony was 98 to 99%. In your professional opinion, the increase in the environmental benefits, do you, as a planner, find that to be a public health, safety, and welfare improvement?
Yes.
You've had an opportunity to review the reports issued by the board's engineer and planner, correct?
Yes.
And just for the record, I'm referring to the Bignell Planning report dated January 16, 2024, and the DNR report dated January 30, 2024, correct?
Yes.
Any objections complying with those requests and recommendations as a condition of approval?
No issues.
Thank you. Chairman, I have nothing further for direct testimony of Mr. Walsh.
Okay, thank you. We're going to go to the board, see if the board has any questions for Mr. Walsh.
No.
Mr. Chairman, I do have a question for the client.
Ms. Chhabra?
So this would be solely, this application is asking for the variance solely for that scrubber. No other buildings, no other structures in the fuse has an intention of exceeding that 100 feet limit.
That is correct.
Okay.
Thank you, Mr. Chhabra. Okay. Any other questions from the board? Okay, we'll go to the Bignell Planning Consultants Report. If I say we go to Mr. Bignell, I don't want you guys both jumping up.
Mr. Chairman, I have no objection to the new scrubber or the height. The applicant has received other approvals along the way. My only concern is that the applicant needs to follow up on all their building permits and all their inspections, and they need to get C of Os. That's why I asked the question whether they're in operation. I don't believe they have certificates of occupancy at this present time, and that needs to get cleared up almost immediately. I spoke with the applicant's engineer, along with Mr. Soltes, the construction official, recently, and maybe just a quick update on how you guys are doing with that.
Yes, yesterday we submitted I submitted a letter certifying 118 construction reports that involve geotechnical, rebar placement, and concrete cylinder testing. Those are all in compliance with the specifications that we prepared for the prior project, and I hand-delivered that to the construction office with a signed and sealed letter certifying such, and at which time I was told we need to now submit the town-issued approvals for the construction, which I'm presuming are the approved stickers, and the applicant is assembling those, and we'll get them over to the town as soon as possible.
And you have to apply them for the final C of Os and everything, the certificate of occupancy.
Yes.
And I would suggest that if you don't have a temporary certificate of occupancy, you apply for that immediately, so you can be operational legally, not have any problems.
We'll do that right away, Mr. Vignal.
Thank you. And Mr. Chairman, I would just ask that, I don't think you can vote tonight because you don't have 5 members for the D variance, but maybe in the next 30 days or whatever, before you vote on this stuff, that they kind of get that stuff in compliance before final approval is granted.
Is that possible?
So just a clarification, I think there are 5.
No, there are 4
That was only
board
4.
members.
Yeah.
There were 5, but one had to recuse. We have 1, 2, 3, 4 board members that can vote.
I'm a zoning
You're a board
officer.
member. Raise your hand. Come on. Raise your hand if you're a board member. Boom. Yeah.
So you can complete your hearing tonight.
Right.
In the meantime, we can get caught up on all the paperwork, and then they could vote when they decide at what meeting they want to vote on, and the 5th member could read the transcript and know what was said this evening.
Sure.
Okay?
That's fair.
Just add to that, you can come up tomorrow and apply for a TCO or a CO.
Sure.
Take the application, please.
Absolutely. We'll do.
Okay. All right. Mr. Bignell with the Bignell Planning Consultants Report. Do you have anything else further to add?
No, I think we're in pretty good shape. They've made the testimonies. Yeah, we just agree on when they do the resolution that all the prior conditions remain in effect. Yeah, and like I said, my concern is making sure they're in compliance with the prior approvals and things of that nature that they're building out there or have built out there.
Thank you. Now we'll go to Michael Bignell for the Delaware Route and Engineering Report.
The only thing I have, if the engineer could quickly, for the record, just address item 7.1 under the solid waste management on how the project complies with the Edison Township solid waste management and state and county recycling mandates.
Yeah, I don't know.
Let me just.
No, I saw the report today, and I hadn't seen that on prior applications I did in the town. So I checked with the applicant, and they believe that they have that information and can assemble it and comply with that.
Okay, thank you. That's all I really had.
And that, Mr. Bignell, that's something that would be supplied on.
Yeah, I mean, that's something that they could find the answer to, and then for the next meeting, before they vote, they could provide that information.
Okay. All right. Great. Thank you.
That's really just for the benefit of the board members.
Okay. Thank you. Okay. Council?
Thank you very much. And I apologize. I miscounted the number of board members. So we will respectfully request, our presentation is concluded. We would respectfully request carrying the vote until there's additional board members, since it's the D variance.
Okay. So you've completed your case?
We have, Chairman.
Okay. So we're going to go out to the public.
Thank you.
First, with anyone within 200 feet of subject property wanting to be heard, if you're within 200 feet of subject property, you have received a notice via certified mail. Seeing none, we will now go out to 200 feet of the property. Seeing none.
Motion to close.
Second the motion.
Motion made by Mr. Sadata, seconded by Mr. Chabra to close the public portion. All in favor signify by saying aye.
Aye.
Opposed, nay. The ayes have it. The public portion is now closed. Madam Secretary, if we have a date for them to be scheduled for a vote.
We have available February 27th, if you're all available for that day.
That would be fine. We appreciate it. Thank you very much.
Okay. Okay, so for anyone here present and for anyone listening at home, this case will be carried till Tuesday, February 27th. No additional notice is required. This is your notice. Thank you very much, gentlemen.
Thank you.
Thank you. We appreciate your time.
Madam Secretary, is there any further business to come before the board?
That'll be all this evening.
Seeing none, the chair will entertain a motion to adjourn.
Motion to adjourn.
Second.
Motion made by Mr. Sadata, seconded by Mr. Chabro. All in favor signify by saying aye.
Aye.
Opposed, nay. The ayes have it. Board stands adjourned. Thank you very much, everyone.